My lord, I will pardon to make a mention. Sorry, your lordship. Item 59 of the weekly list, your lordship. It is rolling in the hearing list since last 3 to 4 weeks, your lordship. It was earlier in the 9, thereafter 12, then now it is at 59. It will hardly take 15 to 20 minutes on behalf. Vigilance case, your lordship, I have also intimated to the Vigilance Council. It's a criminal appeal of the year 2015, your lordship. So my humble
Which Vigilance Council you have intimated?
Madam, when Madam,
I do not know who has been interested. Mr. Das can say that.
Mr. Rizvi, I likely. Mr. Rizvi is entrusted with all our appeal matters. He's likely to.
Madam, I have already intimated to Madam who has been interested in the vigilance cases.
No, I think they have assigned to different council taking year wise. So I do not know what is that number and whom you have told and whether she has been entrusted to do this criminal appeal or not. So unless she gets ready, I have no objection. Sometimes we wait after whenever there is no council, I can take up the matter. But the Vigilance Council must be ready to argue the matter. Okay.
Well, one sample thing. Well, it may be. Well, it is in the 59 year lordship.
Well, I cannot bring it in the supplementary list. Supplementary list only part and matter comes. Yes.
My lord, weekly list today state item number 102, criminal revision 219 or 2010. Already compromise have been made by both the parties. My lord, they have today they have come to the court. So kindly.
What is the offense?
It is for the Nyalaya, Gram Nyalaya offense.
No, is it a case of conviction?
It is a case of conviction, but minor conviction, 6 month.
What is the offense there? What is the item you said? Item is?
Item 202.
202?
102.
Bharti?
The conviction is under section 341, 323 and 34 and penalty is rupees 200.
Please wait.
My lord. Taken at 2.
Okay, the conviction is 341, 323, 34. Then this is the trial court judgment. Then what happened? What about the appellate court?
Well, we have come before the revision court and the stay has been granted by this court.
You are directed to pay rupees 600 for 323, right?
Well,
in default to undergo SI for 20 days. Then you are directed to pay rupees 200 for 341 and in default to 5 days. Okay.
well,
That was by the Nyadhikari. तो magistrates देखिए CR पृष्ठा देखिए
well, there is a Gram Nyalaya Act of his section 33 appeals in criminal cases. There is an appeal in criminal
pass on let us see
33.
Which one you referring?
Section 33.
Notwithstanding anything contained in the Code of Criminal Procedure Code or any other law, no appeal shall lie from any judgment, sentence, and order of the Governor except as provided under. No appeal shall lie where the accused has pleaded guilty. The Governor has passed a sentence not exceeding 1,000 rupees, subject to subsection 2, an appeal shall lie from any other judgment, sentence once to the Court of Session. Every appeal so and so shall be preferred within 30 days. Court of Session may entertain an appeal after the expiry of an appeal preference shall be heard and disposed by the court 6 months.
Clause B of
The Court of Session may, pending disposal of the appeal, direct the suspension of sentence on Court of Session. Okay. You mean to say that since the fine amount has not exceeded 1,000 rupees, it is 800 rupees. So appeal will not lie. That is why you have preferred the revision petition. Okay. So here, what has happened? Notice has been issued.
Notice has issued and opposite party has appeared. I am for the opposite party. Today they have come. IA has already been filed of the compromise petition. Year number 544 of 2020.
What is this act you are referring to?
My lord, Gram Nyaya Act 2005.
Pass on the full act. Have you got the full act with you?
No.
এই দেখি বইটা দেন। What is that act? Tell me.
Gram Nyaya Act 2005.
मगन से बॉयटा कला ग्राम न्यायालय एक्ट 2005 तारे जदि किसी ओडिशा अमेंडमेंट करिया थिबो हला तक मगन call you the other side. You are the opposite party. Which for the petitioner?
And petitioner is Mr. Siddharth. Siddharth Mr.
Call him.
I have told him.
Ask him to remain present.
My lord.
I'm just.
Can it at 2 o'clock? 2 o'clock.
You call him whenever he reaches. I can take it up.
My lord.
Let me verify that. Then we'll see that. Why have you not booked the complete one? What is this practice of? Just,
pardon.
If it is available with you, bring it. Okay. Yes.
One tired of matter, let's say the accused person is suffering in cancer. I have filed a bail application with the London Trial Court for interim bail. That was rejected or completed.
My lord, CRL 1011-2019 for early hearing. I have submitted the paper books and it has been accepted.
Give it.
Supplementary list, item number 1.
Item 1, I'm playing for one Passover, let's say. In the last occasion, Mr. Rai was conducting the case. In fact, due to medical urgency of his father, he had went to Bhubaneswar. He has already returned in the way. Only I pray for one Passover, let's say.
Item 1 cannot be passed. You argue the matter.
But in fact, the brief was entrusted
The
to
last
him.
occasion, my lord, it was already, argument was over from both the sides. Only my learned friend was interested to submit some decisions. 7 EC Act, Convention on 7 EC Act, my lord.
No, LCR worker. You High Court record. High Court record. It was hard on 10/8/2023,
Yes,
means
yes,
last week.
Yes. Almost completed, my lord.
Yes, sir.
But in fact, the brief was assigned to him last night. Also from the chamber, he took the brief. But he will come here, Lordship. On the way, ଖାଲି ବାପାଙ୍କ ଟିକେ ଦେହ ଖରାପ ବୋଲି ଭୁବନେଶ୍ୱର ଟେଷ୍ଟ କରିବାକୁ ଯାଇଥିଲେ. On the way,
That is your internal arrangement. I cannot. It's item number 1. It's a part-hard matter, and yes, next item.
Item number 2.
This case, my lords, the accused was the auxiliary nursing midwife, my lord, NM, my lords, and he was posted at Manikagada PSC.
Why it was kept to today?
My lord, may I submit, my lord, the lordship were hearing is closed and direct to place the decisions and the written note of argument. And that about my lord posed me a question: what are the evidences? What are the documents required for the JOSI card? ମାନେ ଗୋଟେ ଡେଲିଭରି ହେଇସାରିଲା ପରେ ସେ ବେନିଫିସିଆରୀ କଣ କଣ କାର୍ଡ ଦେଖେଇଲା ପରେ ସେ ଡକ୍ଟର ତାକୁ ଚେକ୍ ଇସ୍ୟୁ କରନ୍ତି ସେଇ କଥା ହଜୁର ଆଜ୍ଞା ପଚାରିଥିଲେ। ଜେଏସଆଇ କାର୍ଡ ପାଇବା ପାଇଁ ହେଲେ ଗୋଟେ ଆଧାର କାର୍ଡ ପ୍ଲସ୍ ଜେରକ୍ସ ବ୍ୟାଙ୍କ ପାସବୁକ୍ ପ୍ଲସ୍ ଭୋଟର ଆଇଡି କାର୍ଡ ଏଇ ସବୁ ଡକୁମେଣ୍ଟ ଦରକାର। ସେ ଆଣି ପାରି ନଥିଲା 7/9/2010 ତାରିଖ ଦିନ ଏବଂ ନ ଆଣିବାରୁ ସିଏ ତାପରେ ତା ଆଶାକର୍ମୀ ମାଧ୍ୟମରେ ସେ ତାକୁ ଜଣେଇଥିଲେ ତୁ ଇମିଡିଏଟ ଆଣିଲେ ସାଙ୍ଗେ ସାଙ୍ଗେ ଅନ୍ ସ୍ପଟ୍ ତମେ ଜେଏସଆଇ କାର୍ଡ 1400 rupees ପାଇବ। ସେ ଡ୍ୟୁ ଟୁ ମାଇନରିଟି କମ୍ୟୁନିଟି ତାଙ୍କର ଗୋଟେ ପରଦା ପ୍ରଥା ଯୋଗୁଁ ସିନ୍ସ ଆଇ କଣ୍ଟାକ୍ଟ ୱିଥ୍ ମାଇ କ୍ଲାଏଣ୍ଟ ପରଦା ପ୍ରଥା ଯୋଗୁଁ ସିଏ ଆସିପାରିନଥିଲା। 25/9/10 ତାର ଗୋଟେ ଇମ୍ୟୁନାଇଜେସନ ପାଇଁ ଥିଲା ଆସିଥିଲା। ସେ ବେନିଫିସିଆରୀ ବସିଛି ମେଡିକାଲ ଭିତରେ। ତାପରେ ଇଏ ତାଙ୍କର ଯେ କମ୍ପ୍ଲେନାଣ୍ଟ PW3 ସିଏ ସବ୍ ସେଣ୍ଟରରେ ଥିଲା। ତାପରେ ତାଙ୍କର ଯିଏ ସୁଇପର PW8 ଡକେଇଲେ ତମକୁ ଖୋଜୁଛନ୍ତି କମ୍ପ୍ଲେଣ୍ଟ PW3। ତାପରେ ଗଲା ବେଳକୁ ये टॉयलेट जाइए रेजिस्टरटा बाहर कर 400 टंका से मोबाइल तले रखिदेला। से 400 टंका धरिकी रेस्पोंडेंट से टंका धरी गला बेलू जाइए मेडिकल अफसर पाखु जे से जेएसआई कार्ड पे आई।
Let us see the reasoning of acquittal. What is the reasoning of acquittal?
यही घटना आज्ञा प्रीप्लान गोटे होइछि जेहेतु क्वार्टर रिगार्डिंग क्वार्टर एंड he was not allotted, the present respondent was not allotted for the delivery. Allotted was Ranjita Das. Though she is illness, Sanjiva Rao, my client, deputed to take delivery.
Come to the paragraph number 8 of the judgment.
My lord.
Read it.
My lord. From the evidence of PW1, the medical officer of the concerned Manikogoda PSC, it is revealed that the present accused assisted him in the delivery of the wife of the complainant on 7/9/2010. It is further revealed from his evidence that the check under Janani Suraksha Yojana was prepared by the accused. Further, it is evident from his evidence that in this case, the beneficiary could not take the check at the time of discharge from the hospital on 7/9/2010. The date of delivery, since he failed to produce Xerox copy of mother-child health card, which is required to be produced as per the guideline of Janani Suraksha Yojana, during his cross-examination, it is revealed that since the day till 25/9/2010, never the mother of the child had come to the hospital to collect the check by submitting the copy of mother-child health card. The same fact is also admitted by the complainant PW3 in his cross-examination. The evidence of the IO...
Just a minute. The same fact is also admitted by the complainant PW3 in his cross-examination. Okay. Yes, then?
The evidence of the IO also shows in the alleged night the check could not be issued as it was 12 o'clock night and therefore the complainant was asked to come on the next day with required documents. In view of his evidence, it is found the complainant has not come to the court in clean hand. He has suppressed the fact of not supplying the required documents, which was the cause of non-granting of check under Janani Suraksha Yojana. In the circumstances, the plea of the complainant that the check was not issued on demand of money cannot be accepted. More so, PW1, the medical officer, also states that never after 7/9/2010 till the date of draft, the mother of the child had come to the hospital to collect the check. For the sake of argument, if it is considered that if the complainant's wife was harassed by the accused by not issuing the check, then no reason is found as to why she had not brought this fact to the notice of PW1, the medical officer.
That means prosecution case is that there was demand of money, bribe amount, for which that particular card, Janani
Suraksha Yojana,
that 1400 rupees or something like
yes, ma'am.
That was not paid, and that card particularly requires to that Xerox copy of the mother child health card.
Yes, ma'am.
That was the requirement.
Aadhaar card is requirement, bank passbook is requirement.
Okay. So your case is that she could not produce it on that day. When the date of delivery, which was 7/9/2010, and their case is that it was not paid because there was a demand of bribe money, and since it was not given, that was not paid.
Yes.
So the complainant seems to have admitted, as it appears from the cross-examination, that since that date till 25/9/2010, never the mother of the child had come to the hospital to collect the check, submitting the copy of the mother's child health card. Okay. The evidence of the IO shows that, okay, in view of the evidence, further complainant has not come to the court clean and he has suppressed the fact that supplying required documents, which was the cause for none. Okay. In the circumstances, plea of the complainant that the check was not issued on demand of dowry. Okay. This is the finding. More so, PW1, the medical officer also states that never after 7/9/2010 till the date of trial, the mother of the child had come to the hospital to collect it. Okay. Further argument advanced by the learned counsel. Yes, read out from paragraph 9.
Yes, my lord. Yes, my lord. Further argument advanced by the learned counsel for the accused is that there was no previous demand, and in a trap case, in absence of previous demand, the case of the prosecution cannot be relied upon, to which it is answered by learned special PP vigilance that in complaint petition as well as the evidence of adultery, the complaint clearly speaks about the same. Paragraph 10, my lord. It is found from the evidence of PW1 that at the time of discharge of Leila Begum, the wife of the complainant, after her delivery on 7/9/2010, he, along with the accused Sanjuva Raut and Asa worker Ishta Begum and male sweeper Bikram Naik were present. The same fact is also admitted by PW3 in his cross-examination, though he denies the presence of sweeper Bikram. So, at what time the demand of illegal gratification was made to the complainant is not understood. More so, the evidence of PW1, the medical officer, shows the accused was all along with him at the time of delivery and thereafter, so the pre-demand of bribe by the accused, the complainant fails to prove. In view of the evidence on record after 7/9/10 till 25/9/10, the complainant and his wife had not came to the hospital. How the deal of bribe of ₹400 was decided between the parties is not clear, and it is hard to believe. The same fact is also not clearly mentioned in the complaint of the complainant nor his statement before the IO, and in the court does reveal about the same. The evidence of Idol 7 the independent official witnesses reveals the complainant narrated that accused demanded rupees 500 for sweet on the occasion of birth of his son and rupees 50 for issue of check. The evidence of Widow 7 throws doubt on the plea of the complainant because asking money for sweet on the happy occasion of birth of a son cannot be treated as demand for illegal gratification, and for that delaying the issuance of check is not acceptable. From the evidence of IO, it is found he has not led his investigation to find out whether the allegation of the complainant was true, because in view of the discussion in the foregoing paragraph, suspicion arises in respect of allegation of the complainant. Para 11, my lord. It is in the evidence of Widow 3 that when he, along with his wife, entered inside PSC, the accused called them to the nearby subcenter where the transaction took place, and it is the case of the prosecution that Widow 7, the overhearing witness, was in close proximity of the complainant to hear their discussion and see the transaction and immediately to give signal. The evidence of other PWs shows that when the complainant and his wife were in the subcenter along with the accused, they had taken their position in close proximity. The evidence of the complainant Widow 3 shows the accused received money in her right hand and transferred it to her left hand, and all of them came outside after the check being issued to take counter signature of Widow 1 on it. When the vigilance officials trapped her, no reason is found as to why the accused was not trapped in the subcenter itself, and the vigilance officials waited for her to come to the doctor. This creates a very serious doubt on the genuineness of the trap. In the circumstance, the plea of the defense appears to have force that finding the money on the table when the accused rushed to the doctor to disclose the same, she was trapped by the vigilance officers. The trap became more suspicious when the evidence of withdrawals come out to show that right hand wash with sodium carbonate solution did not turn to pink color, but her left hand wash with the said solution turned to pink, though there is evidence that accused had received money in her right hand and then transferred the same to her left hand.
The C report also says that from the right hand was there was no trace of that powder was found, phenylethylamine powder.
Right.
Where is the C report? Let us see.
400.
The right hand was is R to
Yes, yes.
पाइला तो मिलिला उ नाई कोन सोडियम कार्बोनेट सॉल्यूशन जेतबळे नियाई से सॉल्यूशन टा phenylethylamine was detected in sodium carbonate solution contained in the glass bottle marked as D, R, L and W. So D टा होची से जो डेमोन्स्ट्रेशन बेले, R टा होची आपनकर राइट हैंड, L टा होची लेफ्ट हैंड, आउ W टा कोन के जानी छे?
Glass bottle containing pink color solution, that is both hand wash of the witness, Sri Mohit Das.
अच्छा सर witness राचा, W means witness, okay.
Yes.
You see, the RE is one sealed glass bottle containing pink color solution of the right hand wash of the accused so-and-so. So it has changed color and traces of phenylethylamine was found out.
See,
So here from the how the learning trial court come to that portion again. Now you have seen the C report. अरे C report टा देखिला ना नहीं?
yes,
पेपर बुक रे.
Yes, madam.
R टा कौन जानिले तो?
Yes, madam.
से R टा अछि आपनकर पेज 104 रे.
I've seen.
104 रो आइटम नंबर 2 टा होछि राइट हैंड वाश रो आ ताकू मार्क करा जाइछि R. सेही R रो रिपोर्ट टा आसुछि पेज 100 नंबर 5 रे रिजल्ट ऑफ एग्जामिनेशन ने सबु गुडाको रे phenylethylamine was detected in the sodium carbonate solution. तेणु now you come to the which you are placing that judgment जो portion टा place करथिले सेटा होछि
Page 23.
23 place करते again you place that line.
In
The trap becomes more suspicious. हाँ कुहंतु.
In the circumstances, my lord, उपरू fifth line. In the circumstances, my lord.
अरे पढ़ुथिले परा paragraph number 11 रो.
Paragraph 11.
हाँ in the circumstances पढ़ंतु.
In the circumstances, the plea of the defense appears to have force that finding the money on a table when the accused rushed to the doctor to disclose the same, she was trapped by the vigilance officers. तामाने से टेबुल ऊपर जब टंका टॉयलेट जाइथिले टेबुल ऊपर टंकाटा कंप्लेनेंट 3 रखी देइछि से टॉयलेट रो गला मोबाइल तळे टंकाटा अछि ये टंकाटा धरि कि मेडिकल अफसर पाकु जाइछन ये
टंकाटा कोन दी हाते धरि जिवे ना कोन टंकाटा जदि थुआ आइछि जणे कि टंका थुई दी जाइछि ये रे जणे कोन दी हाते धरि कि जीव ना ताकू राइट हैंड रे धरि कि जीव आगे कि ओटा मोटर ये टंका थुई दी
से कथा जाई सी मेडिकल से जणी चंती ये रेस्पोंडेंट
ओहो आपणकर दीटा जाक हैंड वाश निया जाइछि एवं दीटा का हैंड वाश रे आपणकर फेलमथलिन आसुछि सोडियम कार्बोनेट सॉल्यूशन ने जेते बेले आपणकर हैंड वाश निया गला सेटा बाहर कला गला आपण कहउछन जे मु एब्सेंस रे मु जाइथिली बाथरूम आइला बेलकू मो मोबाइल टा थोई दी जाइथिली मो मोबाइल थले टंका थिला 400 टंका तो 400 टंका मु नेकिन उपरिस्थ ऑफिसर अर्थात PW1 को कहिया गली जाके कि ओडम टंका थोई दी जाई ए आउची आपण प्ली तो टंकाटा जदि नेबे तो आपण को राइट हैंड उठे कि नेबे इफ इट इज ए लेफ्ट यू आर ए लेफ्टी देन लेफ्ट रे उठे कि नेबे तो आपण को दीटा हैंड रे केमती आसिला माने ये आर यू काउंटिंग दैट मनी आफ्टर ये केते टंका रखी दे जाई छी
नो नॉट का
तले okay you continue
disclose the same she was trapped by the vigilance officers. The trap became more suspicious when the evidence of PWs come out to show that right hand wash with sodium carbonate solution did not turn to pink color, but a left hand wash with the said solution turned to pink. Though there is evidence the accused had received money in her right hand and then transferred the same to her left hand. Next, the plea of the defense that the accused some ill feeling with one of her colleagues, Sodamini Malik, relating to the allotment of quarters, who was close to Zulfikar Ali, and at the instance of the Zulfikar Ali, who was instigated by Sodamini, the complainant has filed false complaint in the facts and circumstances cannot be overruled. Besides all this, Leila Begum, the wife of the complainant, who is the beneficiary under the scheme and the actual person to receive the monetary assistance, is not examined by the prosecution nor examined by the IO during investigation, and no reason is advanced as to why she was kept.
All right. You come to the accused statement, page number 40. Question number 23.
Question 23, my lord.
40 पृष्ठार question number 33 रो accused statement. पढ़ंतु कोन लिखा है. Have you got anything else to say in this case? What is your answer?
सबु मिछ कथा.
Stop. सबु मिछ कथा. हाँ. तापरे.
ता 7/9/2010 रे लेला बेगम कंप्लेनेंट स्त्री हेल्थ कार्ड देई पारिलानी किंतु 24/9/2010 जाए आसीनी से दिन आसी मीटिंग रू डाकिले मु चेक देई टॉयलेट जाइछि मो टेबुल टंका रखी देइछंती से टंका रे मु सार पाखु गला बेले विजिलेंस ऑफिसर मो टंका
से टंका नेई से टंका नेई हो
टंका नबा करी मिछ केस देइछ
नो से टंका नेई मु सार को पाखु गला बेले योर डिफेंस प्लीज दैट
मिछ के देइछंती भल काम पई मु स्टेट अवार्ड पाई मते टॉयलेट करि पाउ नाहंती मो क्वार्टर को सौदामिनी मध्य नहीं जाइछि
नो आउथरे पढंतु आपण कहउछंदी चेक देई टॉयलेट को जाइथिले
सबु मिछ कथा ता 7/9/2010 रे लेला बेगम कंप्लेंट रो स्त्री हेल्थ कार्ड नेई पारिलानी किंतु 24/9/2010 जाए आसीनी से दिन आसी मीटिंग रू डाकिले मु चेक चेक नहीं टॉयलेट
चेक देई नहीं नुहे चेक देई टॉयलेट
चेक
जाए
देई टॉयलेट जाइछि चेक देई टॉयलेट जाइछि ओ टेबुल रे टंका रखी देइछंती से टंका रे से टंका नहीं मु सार पाखु गला बेले विजिलेंस ऑफिसर मो टंका नबा करी मिछ केस देइछंती भल काम पाई मु स्टेट अवार्ड पाइछि मते टॉयलेट करि पाउनांती मो क्वार्टर को सौदामनी मध्य नै जाइछि
टंका होची 400 टका
400 टका
100 टंकिया चारटा
यस मैम
हां
यस मैम
PW3 होची complainant
मैम
okay you come to the evidence of PW3 let us see what he has stated
my lord may I place the cross examination of level 3 page
अरे चीप टा पढो तू कोन है
I am page 47 my lord I am the complainant of this case I presented a report before the DSP vigilance for the alleging Sanjuwala Raut ANM Maninggoda Health Center to have demanded illegal gratification of rupees 500 for the delivery of my wife and rupees 50 to supply the check under the scheme Janani Suraksha sponsored by the government. She demanded such gratification on 7/9/2010 when my wife delivered a male child in Manikogoda CSC. When I expressed my inability to pay such huge amount, she reduced the demand to rupees 400, stating that unless it is paid to her, the check would not be issued in favor of my wife. Thereafter, on 2 to 3 occasions, I approached the ANM for issuance of the check. She did not pay heed to it, but constantly insisted me for payment of the gratification of rupees 400. Subsequently, on 24/9/2010, when I again met the accused, she told me to bring rupees 400 on 25/10 so that she will issue the check in favor of my wife. Thereafter, I straight went to Vigilance Office Khorda and presented the written report to DSP Khorda. This is the report scribed by me, already marked at Exhibit 11. This is my signature, marked Exhibit 11/5. DSP instructed me to report before him on the next morning in between 6 to 7 a.m. Accordingly, I proceeded the Vigilance Unit Office and arrived at the scheduled time, reported myself before the DSP Vigilance. On my arrival, I found some more persons in the office. DSP introduced me with the persons who were present inside the office, including Govindachandra Lenka and Mohit Das. I was told to narrate my grievance before the witnesses. Accordingly, I narrated the fact mentioned in my FIR. Thereafter, I produced 4 numbers of 100 GC notes, which were intended for payment to accused Sanjuwala Raut to DSP. After the production of the GC notes, being instructed by DSP, the witness Mohit Das noted down the numbers of the denominations of the GC notes on the paper. One of the constable brought 2 types of chemical powder. He first smeared some chemical in his hand and dipped his hand in the solution, kept a bowl. It could not change.
Okay, you leave it, you come to paragraph 3. Say pre-trap demonstration charandu.
Thereafter, paragraph 3, my lord. Thereafter, at about 9:30 a.m., being well prepared, we proceeded to Maninggoda in vigilance vehicle. We reached according to proceeded and parked our vehicle in a little distance of our village. As per the instruction, myself, Lenka Babu, proceeded towards the village. Thereafter, I hired a auto rickshaw and brought my wife from house. Then myself, Lenka Babu, and my wife, Leela Begum, went to the PSC. We 3 went to PSC and I went inside the PSC. Accused was very much present. Seeing me, the accused out and called me to the sub-center, which was a little distance from the PSC. I accompanied the accused to the sub-center while my wife and Lenka Babu followed me. Lenka Babu stood at the door. My wife entered into the room of the accused. The accused asked me if I have brought the cash and I agreed to it. Then she demanded the cash and handed over the tinted GC notes, but not the 4 folded paper to her. She accepted the cash in his right hand and kept it in her left hand, then opened the register and told my wife to put her signature on the reverse of the check, stating that my wife should go to the doctor and obtain the signature of the doctor. My wife put her signature in the required register in token of receipt of the check, and then we both came out and the accused also came out from the sub-center and came to the PSC. Since Lenka Babu had already convened the pre-arranged signal, the vigilance personnel and the witnesses immediately rushed into the PSC. DSP asked me who is Sanjuval Rao, and I identified, so also Sanjuval Rao herself identified. Then DSP challenged her if she has accepted bribe of rupees 400 from me.
अच्छा कौन just stop कौन हेले ताकू से चेक टा दिया जीवो को डॉक्यूमेंट आनी आपण जो कहउछन आपण प्ली टा what are the documents required to give that check of rupees 1400?
Aadhaar card,
Just a minute. Yes.
voter ID card,
Hmm.
bank passbook,
Huh?
bank passbook,
Hmm.
mother child card, ଆଉ immunization card.
एरा की एविडेंस कार अछि माने ई जो ई डॉक्यूमेंट गुडा को दरकार बेली माने नहले 1400 टका जो चेक टा इशू होबनी एटा आपण कोड पाइले
डॉक्टर एविडेंस अछि
की से डॉक्टर
PW1
ओके देखिले से लाइन टा PW1 रो financial benefit of rupees 1400 can be received only on production of these particular documents seta kodi achi second paragraph is PW1 kochi the financial benefit to such pregnant woman is rupees 1400 financial benefit to be given after delivery of the child in the shape of the check एतियो कहला PW1 जे ता पई आउ ए 15टा जो 4-5टा डॉक्यूमेंट आपण कहउचंती ताकू दबा डिपोजिट करिवा दरकार बेली आपण जो कहउचंती एटा को एविडेंस ना से जो से गाइडलाइन किछि अछि जो थ्रू जणा पड़िबो जे हां नाही ए डॉक्यूमेंट न देले जणको चेक इशू होबो नाही
paragraph
8 अच्छा
as per the guidelines of the Janana Shulka Yojana, ASHA workers are to bring pregnant women to PSC. Ishta Begum was the ASHA worker. The beneficiary could not take the check at the time of discharge from the hospital since she could not produce Xerox copy of mother child health card. As per the guidelines, a check is issued to the mother of the child only. The mother of the child did not come to the hospital to collect the check till 25/10. During the time of discharge of the patient, Leela Begum on 7 and 10, myself Sanjay Rao, accused ASHA worker Ishta Begum and male sweeper Vikram Naik were
तो गोटिए जिंस कहूची माने मदर चाइल्ड रो कार्ड ता ही हेगल हे
भितरे सो इशू बैंक पासबुक इशू दरकार आज्ञा
हां
ता संगे कनेक्टेड रेकॉर्ड होची बैंक पासबुक
कोडी आपण सुनंदु आपण जोटा आर्गुमेंट करूचंदी इट मस्ट बी बेस्ड ऑन एविडेंस आपण जदी ए डॉक्टर टा कहिला ना ए डॉक्टर टा खाली कहूची जे जेरॉक्स कॉपी ऑफ मदर चाइल्ड हेल्थ कार्ड ହେଇଗଲେ ହେଇଯିବ 1400 ଟଙ୍କା ତା ମା ନାଁରେ ଦିଆଯିବ। ଆପଣ ଏଇ କହିଲେ ତା ସହିତ ଆପଣ କହୁଛନ୍ତି ଆଉ 4ଟା ଡକୁମେଣ୍ଟ ଅର୍ଥାତ୍ ଆଧାର କାର୍ଡ, ଭୋଟର ଆଇଡି କାର୍ଡ, ଦେନ୍ ବ୍ୟାଙ୍କ ପାସବୁକ୍ ଏବଂ ଇମ୍ୟୁନାଇଜେସନ କାର୍ଡ, ଏଗୁଡାକ କୋଉଠୁ ଆପଣ ପାଇଲେ?
जननी सुरक्षा गाइडलाइन लेखा ताकर जो फॉर्मेट जो
जननी सुरक्षा गाइडलाइन प्रमाण ହେଇଥିଲା? अरे प्रमाण ହେଇ ଯଦି କହୁନାହାନ୍ତି ଏକ୍ଜିବିଟ କେତେ? ଆପଣ ଗୋଟେ ପ୍ଲିଟା ନଉଛନ୍ତି ନା।
जननी सुरक्षा योजना ताकर सब कलम अछि आधार कार्ड ई सब
ଓହୋ, ଆପଣ ଗୋଟେ ପ୍ଲି ନଉଛନ୍ତି ଜନନୀ ସୁରକ୍ଷା ଯୋଜନାରେ ଏଇଆ ଦରକାର, ତ ୟୁ ଆର୍ ରିକ୍ୱାର୍ଡ ଟୁ ପ୍ରୁଭ ଦ୍ୟାଟ ସେ ଜନନୀ ସୁରକ୍ଷା ଯୋଜନା କାର୍ଡ ଟା ମାନେ ସ୍କିମ ଟା ପ୍ରମାଣିତ ହେଇଛି, ଏକ୍ଜିବିଟ ମାର୍କ ହେଇଛି। କାଇଁ लिस्ट ऑफ एग्जिबिट्स अच्छी कौन प्रिपरेशन सब करूछन कि बुझी पान। जननी सुरक्षा कार्ड एतर कोठी अछि? भाग 3 भाग 4 अच्छा मु एत द्वारा घोषणा करुछि स्वान सब ठारू 1400 टंका डाक्तरखाना रे प्रसव कराइथिबा जोगु जननी सुरक्षा योजना अंतर्गत आर्थिक सहायता ग्रहण करछि। So this is a document.
My lord, exhibit 2. Exhibit 2.
Wait, exhibit 2, ठीक, you are right. Then all right, सी टंका रिसीव करिवाटा ए डॉक्यूमेंट रो प्रमाण होची, राइट। वर्तमान क्वेश्चन होची एवं सेई दिन ही आपन को केस होची चेक इशू हला, जो दिन डेट ऑफ ड्राफ्ट सेई दिन ही इशू हला। तो आपन को केस जदी होची जे 7 तारिख रे पिला जन्म हला आउ 25 तारिख रे पर्यंत डिले हला, कारण होची सी आसिलानी, नंबर 1। नंबर 2 जो डॉक्यूमेंट गुड़ाक दरकार थिला से गुड़ाक मध्य आनी प्रोड्यूस हे नथिला, तेणु सेई दिन प्रोड्यूस हला एवं सेई दिन आपण चेक इशू कले, ठीक तो?
आज्ञा।
अच्छा, जदि चेक टा आपण को पाखे ए जो से डॉक्यूमेंट गुड़ाक आपण को पाखे रे सेई दिन प्रोड्यूस हेई थाए, तो ऑब्वियसली से डॉक्यूमेंट गुड़ाक सीज हेई थांदा, आपण फर्स्ट टू सीज हेई थांदा ना। Whether those documents were seized, because you are taking a plea that for want of number 1, 2, 3, 4, 5 documents, it was not earlier handed over, and on that day the check was handed over. That means on that day he produced those documents.
Yes.
So if he produced the documents and immediately vigilance officials came to you, then it could have also seized from your possession on that day.
Yes.
And अपन ताकू रखी किन तो पुनी चेक देबे ना, तो whether those documents were seized, काई की कोची
रजिस्टर से जो रजिस्टर ता से रजिस्टर सिग्नेचर कला परे अलमीरा से रजिस्टर ता से दियन बेनिफिशियरी आइला रजिस्टर रे सिग्नेचर करिवो, कार्ड फार्ड सब दबो से
अरे बाबा से कार्ड घरिया जबत ही मु आपन पचारुची एई कार्ड रु जणा पड़ची 25 तारिख दिन से 1400 टका ग्रहण करची, सेटा डिस्प्यूट नहीं। 1400 टका ताकू देइचंती 25 तारिख दिन सेटा डिस्प्यूट नहीं। क्वेश्चन होची डिले और डिमांड। ता प्रोसिक्यूशन केस होची जे आपण डिले करी चालिले जे 400 टका न देले मु आपन को 1400 टका रे चेक देबी। आपण गोटे प्ली नउचंती जे नाही ठीक कथा नुहे एटा, सी तापरे पळेले से दिन 7 तारिख दिन डिलीवरी हला पर राती एइतला से पळेले, तापरे जो डॉक्यूमेंट रिक्वायरमेंट थिला for issuance of this check of rupees 1400 that he could not produce, and he had also not come with his wife. That was the reason for which delay occasioned. है तो जदि सेया हला, जदि आपनकर प्ली अनुसार किछि डॉक्यूमेंट वांटिंग जोगु ता पेमेंट हो नथिला एवं 25 तारिख रे अल्टीमेटली पेमेंट हला, So it presupposes that after receiving those documents, you have issued the check. So whether my next question would be that whether those documents were seized by the vigilance officer. It would strengthen your defense plea that yes, for want of these documents, the check was earlier not issued on particular day that was done, and he produced all those documents for which the check was issued. ତେଣୁ ତାର ସେ ଯୋଉ ସିଜର କଲା ସେଦିନ ଟିଏଲଓ କିଏ କେତେ ନମ୍ବର ସାଗି ଟିଏଲଓ ଏଭିଡେନ୍ସ କୁ ଆସିଲେ କଣ ସେ ଜବତ କରିଛି ସେ ଛାଡନ୍ତୁ ସେ ଜବତ କଣ କରିଛି ଏବେ ଦେଖିବା ନା ସବୁଗୁଡା ନୁହେଁ ଆପଣ ପଳେଇ ଆସନ୍ତୁ ସେ ଯୋଉ ଧରା ପଡିଲା ପରେ ଯୋଉ ଜବତ କରିଛି କଣ ଦେଖିବା ଅନ୍ ବିଙ୍ଗ ପ୍ରଡ୍ୟୁସ ଦି ଟେଣ୍ଟେଡ ମନି ୱାଜ ରିକଭର୍ଡ ହଁ ବର୍ତ୍ତମାନ ପାରାଗ୍ରାଫ 3 ର last 3 to 4 lines ପଢନ୍ତୁ on being proceeded to inside the health center ଆପଣ ସେଇଠି ପଢନ୍ତୁ
on being proceeded to inside the health center in our office room the tainted money was recovered from our left grip by witness Mohit Kumar Das with the assistant of Lady Inspector Lalita Parida. The serial number of tainted money.
Left grip माने कौन जान ले तो अपन माने as if you are holding that money. अपन बाँ हाथे रे से टंका थिला से अवस्था रे एटा रिकवरी है से मोबाइल फोइल तलो एगुडा को नथिला अपन गोटे जो प्ली नउचंती ओके अगेन रीड इट आउट
left grip by witness of Mohit Kumar Das with the assistant of Lady Inspector Lalita Parida. The serial number of tainted money tailed by witness Mohit Das with the number noted down in the preparation report and gave an endorsement in the copy of preparation report disclosing that money is recovered tailed with number mentioned in the report. As at my direction, Constable Balyar Singh prepared solution of sodium carbonate and both the hand wash of accused were taken separately. And in both the cases, solution turned to pink, which were preserved in separate clean glass bottles, which were marked L and R. The hand wash of Mohit Das was taken in sodium carbonate solution, which turned to pink, and solution was preserved in clean glass bottle marked W. By Exhibit 18, I seized the exhibits L and R, whereon Exhibit 18 by 3 in my signature. MO 2 and 3 are those bottles respectfully. By Exhibit 19, seizure list, I seized the tainted bribe money recovered from the possession of the accused, whereon Exhibit 19 by 3 is my signature. MO 5 is the said tainted money. By Exhibit 20, seizure list, I seized the Exhibit W along with the copy of preparation report, Exhibit 20 by 3, from the possession of the witness Mohit Das, whereon Exhibit 20 by 4 is my signature. MO 4 is the said bottle. Exhibit 20 by 5 is the endorsement with signature of Mohit Das regarding the count and tally of tainted money with that of the preparation report. At the spot, the complainant produced check number such and such dated 25/9/10 for the rupees 1400 in original issued in favor of Laila Begum, signed by accused and medical officer Maninggoda PSC. The paper Exhibit 13 by 2 containing the tainted money, the original check along with attested Xerox copy of the said check, Exhibit 11 were seized by seizure list Exhibit 13 on production by the complainant, whereon Exhibit 13 by 6 is my signature. After seizure, the above said original check was left in Jima of the complainant. Exhibit 13 by 7 is the Jimanama, and Exhibit 13 by 8 is the signature of the complainant, and Exhibit 13 by 9 is my signature. On being directed, the accused produced disbursement register relating to the disbursement of check under Janani Surakha scheme of Maninggoda PSC Exhibit 10, which was seized along with original Janani Surakha card of Laila Begum Exhibit 2 and its attested copy by its seizure list Exhibit 21, whereon Exhibit 21 by 2 is my signature. Here's number 33, serial number 64, dated 25/9/10, Exhibit 10 by 1 of the said register reveals the check of rupees 1400 during number such and such has been issued in favor of Laila Begum. The brass seal used for sealing the exhibits was left in Jima of Mohit Das to produce as and when required. Exhibit 22 is the Jima.
So that means that this Janani Surakya card, which was required to be produced also, that was produced and that was also seized as per seizure list exhibit 21.
Original.
Original one. And in that original, the endorsement is there about receipt of rupees per. But not about all these cards, etc., which you are telling. Nobody has stated that all these documents are required. Aadhaar card, voter ID card, it is a bank passbook. It's only requirement as per PW1 has also stated, and it is also found from the evidence of the TLO that there was an entry that it has been given to you. That check was also seized from the complainant, and that apart, in that original Janani Suraksha card, the entry is there, which has been marked also, that ମୁଁ 1400 ଟଙ୍କା ଗ୍ରହଣ କଲି ବୋଲି କରି signature ଦିଆଯାଇଛି. So these things were not required. Nobody has stated it is. Okay. Yes, Mr. What do you say now?
I'll just take down 2 to 3 minutes. My lords, in this case, my lords, the scope of interference, I understand, my lords, is the factum of perversity, my lord. And in this case, my lord, if lordship can paragraph 8 to 10, my lord, contains 6 grounds for which the accused in this case was let off. One, there was no pre-demand. Second, from 7/9/2010 till the delivery, and that is the date of delivery of 7/9/2010, till the date of trap on 25/9/2010, the complainant and his wife had never come to the hospital. So there was no deal of rupees 400. That is the second findings. And the third findings is that in lieu of contacting Dr. Pidulwan, why he was not informed about these pre-demands. And the third grounds for which the court entertained suspicion that why the accused was not trapped in the sub-centers itself, why the vigilance also waited for her to come out from the doctors. And my lords, another doubt, my lord, why Laila Begum, the wife of the complainant, was not examined. And another finding is the right hand wash with the sodium carbonate solution didn't turn to pink colored, my lord. This is all based on, my lords, no evidence, my lord. And in fact, those findings are also bristling with contradiction and inconsistency
No,
with
that
the evidence.
right hand wash which was taken, that was on the, they have also stated, witnesses have stated that it did not change any color. From that, the London trial court has extracted. But in fact, the C report indicates that the presence of phenolphthalein was there.
If a lordship permits, my lord, this particular one-line findings regarding the change of color, my lord, based only in one witness, my lord, statements. But based on the statements of one witness, my lord, other witnesses, my lord, they have consistently, held with regard to change of color. Like
right hand was.
Yes.
And who has stated that it did not change color?
That is PW7, my lords. Page 66, my lords.
PW7. Who is he, PW7?
A raiding party member.
Okay. Mohit Kumar Das.
PW7, page 66, notes.
But other witnesses have stated that
all supported the prosecution with regard to change of color, with regard to the right hands, like the decoy, warring witness.
No, just show me that particular line from PW7. Where is stated?
Page 66 of Lordship Brief Notes.
That is no, that about that line.
Yes, no, I'm coming to this notes.
Not changing.
Your Lordship, turn to page 67. I'm placing the fifth line from the bottom. Page 67, fifth line from the. It starts from the left hand wash of the accused turned to pink color, but the right hand wash didn't change to any color. This one line.
Just a minute.
Page 67, I'm placing the fifth line from the bottom. The line starts, the left hand wash of the accused turned to pink color, and the right hand wash didn't change to any color. So this one line, my lords, is the foundation of this particular perverse appreciation and the findings of the London trial courts. Whereas
it is happening like this. Okay, right hand wash did not change the color. You mean to say that the other witnesses have stated that right
Consistent.
hand? Who are L?
All the two eyewitnesses that is
TLO, TLO?
Yes, ma'am.
We'll come to that line then. PW?
PW9, my lords.
PW9 देखिए से line टा
Page 84, my lords.
84.
Page 84, lords, you got that page, my lords?
Yeah.
I am placing the third line from the top, my lords. Or the para 4, my lords. As at my direction, Constable Balayar Singh prepared solution of sodium carbonate, and both hand wash of the accused were taken separately, and both the cases sodium turned to pink, which are prepared in separate clean glass bottles, which are marked as L and R.
Yes, in both, right, you are right.
You'll also turn to the second witness about the right hands. That is PW 8 also, page 73.
PW?
PW 8, the shadow witness at page 73, PW 8.
No, is your right hand was done.
You'll also turn to para 4, page 75. I'm placing para 4 minutes, leaving the first two lines.
Yes, I got
both
it.
hand wash of the accused were taken in sodium carbonate solution separately, and both the solutions turned to pink color, and solution were kept in the two separate bottles and given mark L and R. This is all consisting with the TLO. And Millards are ultimately the PW3, page 47, the exact line. At page 51. Thereafter, page 51, middle portion, there is some marking on the left side.
Everybody seems to have stated that you are holding the same in the left hand. And from your left hand, that was seized. You accepted it in right hand. Okay. Then you change this to left hand. Then the other formalities were done. That means that check was issued, signatures were taken in that register, and also in that original Janani Suraksha card. So you this question must have put to you in the 313 statement. Je apanଙ୍କର ବାଁ ହାତରୁ ସେ ଯୋଉ ଲାଞ୍ଚ ଟଙ୍କା 400 ଜବତ ହେଇଥିଲା. So what is your reply to that? From your left hand, rupees 400 was seized. You said no.
No.
Okay. ମିଛ କଥା ଆପଣ କହିଛନ୍ତି. All right. If you have said ମିଛ କଥା, then it is your further plea that check ଦେଇ toilet ଯାଇଛି, ସେ table ରେ ଟଙ୍କା ରଖି ଦେଇଛନ୍ତି, ସେ ଟଙ୍କା ନେଇ ମୁଁ ଆଚ୍ଛା ଟେବୁଲ ଉପରେ ଟଙ୍କା ନେଇକିନି ଆପଣ ରଖିଦେଇକିନି ଗଲେ, ଯୋଉଟା କି ଆପଣ କହୁଛନ୍ତି ନେଇକି ଯାଉଥିଲେ ଆପଣଙ୍କ ସାରଙ୍କ ପାଖକୁ, ସେତିକି ବେଳେ ଆପଣ ଟ୍ରାପ୍ ହେଲେ. ଏଇଟା ହଉଛି ଆପଣଙ୍କ କେସ୍. ଆଉ ସେ ଯୋଉ ମିଠା କଥା କୋଉଠୁ ଆସିଲା? ସେ ଯୋଉ କଣ
ସୁଇଟ୍?
ହଁ, କୋଉଠୁ ସେଟା ହେଲା? ସେ କି କହିଲା? ସେ
ଡକ୍ଟର ବୋଧେ କହୁଛି. ଡକ୍ଟର?
କୋଉ ଡକ୍ଟର?
PW1.
କଣ କହିଲା? ସିଏ କେମିତି ଜାଣିଲା ଯେ 500 ଟଙ୍କା ତାକୁ ମିଠା ପାଇଁ ଦେଇଛନ୍ତି? ଇଏ ତ ନିଜେ କହୁନାହାନ୍ତି ମିଠା ପାଇଁ ଦେଇଛନ୍ତି.
DW8 ବିକ୍ରମ ନାୟକ.
ସିଏ କୋଉଠୁ ପାଇଲା ସେ ଖବର? Come to that line, particular line.
My lord, page 22. The evidence of Schedule 7, the independent official witness reveals the complainant narrated the accused demanded 500 rupees for sweet on the occasion of birth of his son and rupees 50 for issue of check. The evidence of Schedule 7 throws doubt on the plea of the complainant because asking money for sweet on the happy occasion of birth of his
PW7.
my lord.
Demand money 500 ଟଙ୍କା ନଥିଲା, demand money ଥିଲା 400 ଟଙ୍କା। तो आपण केस होची आगे 500 ଟଙ୍କା 500 प्लस 50 ଟଙ୍କା मिठा ପାଇଁ ମାଗିଥିଲା ଏବଂ ଇସ୍ୟୁ କରିବା ପାଇଁ 1400 ଟଙ୍କାର ଚେକ୍। ତାପରେ 400 ଟଙ୍କା ଫିକ୍ସ ହେଲା ଏବଂ PW1 ର जो एविडेंस टा आपण प्लेस करथिले पेज 94 रे The mobile of the accused was on the table, paragraph 4. Paile seta?
Page 94.
Yes. 94, maybe of the paper book.
Yes. That is the statement of the Bikram Naik.
Right, DW1.
Yes, ma'am.
Come to paragraph 4.
Yes, ma'am.
Say...
On 25/9/10 at about 11 to
No,
11.
you come down. Our 5 line chhad diyantu. The mobile of the accused was on the table. And
the mobile of the accused was on the table. And under the mobile there was some cash. Sanjiwala came out of the toilet. So I informed her to attend the meeting as required by the MO. So she brought the phone and the cash in the left hand and came to the MO, medical officer. At that time, vigilance officials reached her and disclosed their identity and she was nabbed by them.
ଆପଣଙ୍କର ଏଇଟା ହଉଛି ଡିଫେନ୍ସ ପ୍ଲି, ଆପଣ ଏଇ ପ୍ଲି ହିଁ ନେଇଛନ୍ତି ଆପଣଙ୍କର ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ ହେଲା। ଆକ୍ୟୁଜ ଷ୍ଟେଟମେଣ୍ଟ କୁ ଆଉ ଥରେ ପଳେଇ ଆସନ୍ତୁ ସେ ଲାଷ୍ଟ କ୍ୱେଶ୍ଚିନ୍ କୁ। ମୁଁ ଟଏଲେଟ ଯାଇଛି, ସେ ଟେବୁଲ ଉପରେ ଟଙ୍କା ରଖିଦେଇଛନ୍ତି, ସେ ଟଙ୍କା ନେଇ ମୁଁ ସାରଙ୍କ ପାଖକୁ ଗଲାବେଳେ ଭିଜିଲାନ୍ସ ଅଫିସର ଧରିଲେ ହେଲା, ଯୋଉଟା କି DW1 ଆପଣଙ୍କର ସାକ୍ଷୀ ମଧ୍ୟ କହୁଛି ହେଲା। ଏଇଆ ତ କଥା ଆଉ କଣ? ଆଚ୍ଛା, ଏଇଆ ଯଦି ହେଇଥାଏ ତ ଆପଣ ଯାଇଥିଲେ ଟଏଲେଟ ଯାଇଥିଲେ, ଟଏଲେଟ ରୁ ଫେରିଲା ବେଳକୁ ଆପଣ ଦେଖିଲେ ଯେ ଆପଣଙ୍କର ମୋବାଇଲ ତଳେ ଟଙ୍କା ଥୁଆ ହେଇଛି, ତ ମୋବାଇଲ ଉଠେଇଲେ ଡାହାଣ ହାତରେ, ଟଙ୍କା ଉଠେଇଲେ ବାଁ ହାତରେ, ତାକୁ ଧରିକିନି ଆପଣ ଯାଉଥିଲେ PW1 ପାଖକୁ, ସେଇ ସମୟରେ ଆପଣ ଟ୍ରାପ୍ ହେଲେ, ରାଇଟ୍? ଯଦି ଏଇଆ ହେଇଥାଏ ताहले टंका तो राइट हैंड रो संस्पर्श रे आसीनी कारण राइट हैंड संस्पर्श रे आपनकर मोबाइल टा अछि तेणु मोबाइल टा टंका ऊपर थुआ हैतला जदी मोबाइल रे जो टंका रे जदी फेलम तलिन लागि थाए ताले ऑब्वियसली मोबाइल को टच करथिबो एवं आपण मोबाइल धरिथिबे जेहेतु सेथिरु आसुथिबो आपनकर कलर चेंज होथिबो so that is how you want to say that मोर दीटा हैंड वाश रे ये ही जाइछि
Lordship permits my lord may submit one line, but thereafter I'll take my sheets. My lordship, you can see the main grounds of acquittal is that that is no pre-demands of illegal gratification.
that is corroborated by PW1
One and also the
PW1 has not stated about any demand that any demand was made on 7th
PW 3 and 8.
PW1 was throughout present as it appears but he has not stated about any demand on that day and they left PW3 along with his wife who delivered the child. They left the hospital on 7/9 in the night. Prior to that, PW1 was present throughout and not stated about any demand raised. But this PW3 stated that
PW3 at page 48, 47. 47, in the middle portion, she demanded such gratification on 7/9/2010 when my wife delivered a male child in Malikhana CSM. This is prior to the date of the trap. Date of the trap is on 25th March. So this is a prior demand. This has been corroborated by PW8 at page 73 minutes. 73 minutes, the PW8 says the complainant told that he was placed with a son and he was to get financial assistance of rupees 1400 under Janani Surekha Yojana, and AMA was initially demanding 550 to give the check of rupees 1400. And later she reduced this to 400. This is the pre-demands prior to the date of trial. So these findings of the London Trial Court that there is no pre-demand is purpose. This is my humble submission. And secondly, with like a change of color and all this thing only on the basis of the statements of PW7 is also another purpose piece of findings, because other witnesses consistently and fully supported the change of color of both the hands. And I need not place all the legal position lordships aware, lords, but for recording a conviction under section 713(1)(d) and lords, the prosecution has to prove the demand acceptance of illegal gratification, whether by direct evidence or by subcontinence evidence. And for for section 7, lords, to bring on the offenses, there must be offer which emanates from the bribe giver, which is accepted by the public servants, and similarly a prior demand by public servant when accepted by the bribe giver, and in turn there is a payment made which is received by the public servant. In all this case, all these ingredients are present in this case more, and particularly the findings of the learned trial court in acquitting the accused person. There are why he didn't ask the doctors, why he didn't inform the doctors, why the complainant wife was not examined, why he was not trapped in the centers and sub centers where he waited for the doctor. These are all based on no evidence, again resulting with publicity.
Page 53, my lord, in cross-examination, the PW3 has stated, actually, there is some
Let's take down. ECRLA 29 of 2018.
I have given the my lords some decisions of my lords.
All right. The respondent, Srimati Sanjubala Raut, faced trial in the court of Lenin Special Judge Vigilance Bhubaneswar in TR case number 26 of 2011 for offences punishable under section 13(2) reduced section 13(1)(d) and section 7 of the Prevention of Corruption Act 1988, hereafter PC Act, on the accusation that she, being a public servant and functioning as ANM of ANM ର full form ଟା କଣ?
Auxiliary nurse midwife.
କଣଟା?
Auxiliary nurse midwife.
Auxiliary nurse
midwife.
Nursing maid.
नहीं नहीं टा टर्म टा auxiliary nurse midwife bracket
Nursing midwife.
auxiliary nursing midwife bracket रे hereafter for short ANM ହେଲା of Manikgoda Health Center on 29/5/2010 by corrupt and illegal means or otherwise abusing her position as a public servant, obtained for herself pecuniary advantage to the extent of rupees 400 from the complainant Mehboob Hussain Khan (PW3) for releasing the check amount of rupees 1,400 लिखिए 1,000 words लिखिए in favor of Laila Begum, the wife of the complainant, under Janani Suraksha Yojana, as Laila Begum had given birth to a male child on 7/9/2010 at Manikagoda Hospital, and that he accepted rupees 400 from the complainant (PW3) as gratification other than legal remuneration as a motive for releasing the check of rupees 1,400 in favor of the wife of PW3. The London Trial Court, the London Trial Court by judgment and order dated 28/12/2016 found the appellant not guilty under section 13(2), reduced section 13(1) D, so also section 7 of the PC Act, and acquitted him of all the charges. Hence, the state of Orissa vigilance has preferred this GCRLA, challenging the impugned judgment and order dated 28/12/2016. ठीक है, ऊपर प्रथम लिखिए तो the respondent face trial will. Okay. The prosecution case in short is that Laila Begum is the wife of the complainant (PW3). She gave birth to a son, male child, at Manikagoda Primary Health Center on 7/9/2010. PW1, Dr. Naushad Ali Khan, and the petitioner assisted in the delivery of the child. The state government had floated a scheme, namely Janani Suraksha Yojana, and Laila Begum was supposed to receive a check of rupees 1,400. You please take your seat. 1,400 bracket like that. After giving birth of her child in the government hospital. It is the prosecution case that the said check was not issued by the respondent who was in charge of it, and there was a demand of rupees 500 for delivery of service rendered and rupees 50 for the issuance of check. When PW3 complainant bracketer PW3 expressed his inability to meet such demand, the demand amount was reduced to rupees 400. And the respondent declared that without fulfillment of such demand, the check would not be issued. PW3 repeatedly approached the respondent for such purpose, and ultimately on 24/9/2010, PW3 agreed to pay the illegal demand of rupees 400 to the respondent, which was to be made on 25/9/2010. Accordingly, a written complaint was made by the complainant before the Vigilance DSP Khurda, and the case was registered as Bhubaneswar Vigilance PS case number 57 dated 24/9/2010 under Section 7 of the PC Act against the respondent. And after registering the case, the DSP Vigilance Khurda sent the report to SP Vigilance Bhubaneswar, which was also received on the same day by the SP Vigilance, कौन लिख रहा? The written report लिख रहा ना, was received by the DSP vigilance लिखते हैं तो अच्छा हाँ ठीक है नहीं DSP vigilance receive कला 24 नौरे then he sent it to SP vigilance लिखते हैं तो हाँ ठीक है then SP vigilance received the same and directed the OIC Bhubaneswar Vigilance PS to register the case and the case was entrusted to Sri B.N. Mishra. B.N. Mishra कितने नंबर सा की? 9 PW9 अच्छा विश्वनाथ मिश्र था नाडा पूरा लिख दिया विश्वनाथ मिश्र DSP विजिलेंस PW9 लिख लो था of Khurda to lay the trap. PW9 examined the complainant bracket PW3 made requisition to principal School of Horticulture Khurda in respect of one class 2 and class 3 employee for secret assembly as witness in the trap. On the same day at about 4:35 p.m. as per the direction of the principal Gobind Chandra Lenka कितना नंबर सा की PW8 assistant horticulture officer and Mohit Das examination दी कितने PW अच्छा मोहित कुमार दास कर दूँ PW7 junior clerk of his office attended the vigilance office Khurda and they were directed to appear in the vigilance office Khurda on 25/9/2010 at 6:30 a.m. On 25/9/2010 at 6:30 a.m. PW9 along with other official staffs and PW7 and 8 assembled in the official chamber of PW9 at Khurda, where PW3 was introduced to the other group members and he narrated allegations against the respondent. PW3 produced rupees 400 which were 400 rupees denominations before PW9. The constable Amulya Ratno Bira bracket PW6 prepared the sodium carbonate solution in a clean glass bowl and inserted his finger in it, but the color of the solution did not change. He processed the currency notes produced by PW3 with phenolphthalein powder, and when inserted his finger in the sodium carbonate solution, it turned to pink. The currency notes were wrapped with a white paper and it was handed over to PW3, the complainant. The pink color solution was preserved in a bottle and labeled and sealed, being signed by the witnesses, PW3, and it was marked as Exhibit D for identification. Personal search of PW3 was taken and it was found that he had nothing except the cash which was handed over to him by the vigilance officials. PW3 was instructed to deliver the money to the respondent only on her demand. The numbers of the tainted notes were noted down in the preparation report. Witness Govind Chandra Lenka bracketed PW8 was directed by PW9 to accompany PW3 to the respondent to overhear the conversation between the complainant bracketed PW3 and the respondent, and after transaction was over, he was supposed to give the signal by rubbing his forehead, and accordingly preparation report bracketed Exhibit 12 was prepared, wherein the signatures of the witnesses and PW3 were taken. The preparation was completed by 9:15 a.m. and then the top party members left to village Manikogoda, where they reached at about 11:15 a.m. PW3, his wife along with PW8 proceeded little ahead of the trap party members to the PSC. Near the PSC, the trap party members took their respective positions and PW3 and his wife and PW8 went inside the PSC. It is the further prosecution case that when PW3 and his wife entered into the room of the respondent, the latter asked PW3 whether he had brought the cash, and when PW3 answered in affirmative, then the respondent demanded the cash and the tainted GC notes were handed over to the respondent. The respondent accepted the cash in her right hand and kept it in her left hand, and then opened the register, told the wife of PW3 to put her signature, on the reverse of the check, stating that his wife should go to the doctor and obtain the signature of the doctor. The wife of PW3 put her signature in the required register in token of receipt of the check, and then both came out, and the respondent also came out from the sub-center and came to the PHC. PW8 had already given the pre-arranged signal to the vigilance personnel, for which the witnesses immediately rushed into the PSC PW9 PW9 TL होता हाँ हाँ ठीक राइट ठीक है कौन लिखेगा? Just what sentence? हाँ ठीक है. PW9 asked about the respondent and when she was identified, PW9 challenged her whether she had accepted the bribe of rupees 400 from PW3. The respondent got nervous and fumbled and ultimately admitted to have accepted and showed the cash which was still in her left hand. Thereafter, the respondent was again taken to the sub-center by the vigilance police there in the sub-center, being instructed by PW9 Mohit Das, bracket PW7, took the amount from the respondent, compared the numbers and denominations which found place in the copy of the report Exhibit 12 and declared that it tallied. The right hand was and the left hand was of the respondent with the chemical solution were taken separately and it was preserved in two separate bottles. The bottles were properly sealed and the signatures of the witnesses, including that of the complainant, bracket PW3, were obtained on the paper slip and affixed to those bottles. Seizure lists were prepared, check was seized, detection report was prepared, a copy of the detection report was handed over to the respondent, which she received after putting her signature. On completion of the entire detection formalities, the statement of PW19 was recorded before the magistrate. Then who has investigated this case? This is the TLO part.
Yes.
Yes. That is PW10. PW10 Inspector Vigilance Khurda Unit under Bhubaneswar Vigilance Division took over the charge of investigation from PW9 on 25/9/2010. During investigation of the case, he examined the complainant (PW3) at Khurda Vigilance Office. And on 11/10/2010, the statement of PW3 and overhearing witness PW8 were recorded by Magistrate Bhubaneswar under Section 164 CRPC. On the same day, the exhibits marked as Exhibit R, L, W, and D were sent to SFSL for chemical examination and opinion. Some more witnesses were examined by the IO.
Sanction orders.
On 16/12/2010, requisition was placed before the medical officer Manikogoda PSC for supply of the documents relating to Janani Suraksha Yojana and admission and discharge of the wife of PW3 and supply of check of rupees 1,400. The report from the SFSL was received on 25/2/2011. On 29/3/11, PW10 had a pre-sanction discussion with the CDMO Khurda by producing the FIR and other relevant documents. On 31/3/2011, PW10 received the sanction order from CDMO Khurda against the respondent. By Exhibit 16. On 31/3/2011, on completion of investigation, PW10 submitted charge sheet against the respondent under Section 13(2), read with Section 13(1)(d)(7) of the PC Act. The defense plea of the respondent was one of denial. and it was pleaded that on 7/9/2010, the wife of PW3 could not produce the health card, and on 24/9/2010, PW3 came with his wife and received the check from the respondent It is the further defense plea that from 7/9/2010 till 24/9/2010, neither the appellant nor his wife had come to receive the check. It is further pleaded that after issuing the check, when the respondent had been to the washroom, the complainant placed the tainted money on her table, and while the respondent was carrying the money, to PW1, at that point of time, she was apprehended with the money and a false case has been instituted. कौन लिख रहे लास्ट ईयर? In order to prove its case, the prosecution examined as many as 10 witnesses. Take down this. Exhibits. One Bikram Naik was examined as DW1. The Lennon trial court, after assessing the oral as well as the documentary evidence on record, has been pleased to hold that from the evidence of PW1, the medical officer of Manikogoda PHC, it revealed that the beneficiary could not take the check at the time of discharge from the hospital on 7/9/2010. That is the date of delivery, as she failed to produce the Xerox copy of the mother-child health card, which was required to be produced as per guideline of Janani Suraksha Yojana. And he has further stated that till 25/9/2010, the wife of the complainant, along with her child, had not come to the hospital to collect the check by submitting the copy of the mother-child health card. And the said fact is also admitted by the complainant PW3 in his cross-examination. The Lennon trial court further held that the complainant PW3 has not come to the court in clean hand. Stop. He has suppressed the fact of not supplying the required documents, which was the cause of non-granting of the check under Janani Suraksha Yojana. And in such circumstance, the plea of the complainant PW3 that the check was not issued on demand of money cannot be accepted. The Lennon trial court further held that if the complainant's wife was harassed by the respondent by not issuing the check, then no reason is found as to why she had not brought this fact to the notice of PW1, the medical officer, which also creates suspicion regarding the plea of the complainant. It was further held that it is not understood as to at what time the demand of illegal gratification was made to the respondent. More so, the evidence of PW1, the medical officer shows that the respondent was all along with him at the time of delivery and thereafter, and therefore the pre-demand of bribe by the respondent to the complainant is not substantiated. And the deal of bribe of rupees 400 decided between the parties is not clear, and it is hard to believe. It was further held that the evidence of PW7 throws doubt on the plea of the complainant PW3, inasmuch as asking money for sweet on the happy occasion of birth of a son cannot be treated as demand for illegal gratification. From the evidence of the IO, it was found that he had not laid his evidence, a investigation, to find out whether the allegation of the complainant was true, and that suspicion arises in respect of allegation of the complainant. The London trial court further held that there was no reason as to why the respondent was not trapped in the sub-center itself, and the vigilance officials waited her to come to the doctor PW1, which creates doubt about the genuineness of the trap. The London trial court further held that the plea of the defense appeared to have force, that the finding the money on her table when the respondent rushed to the doctor to disclose the same, she was trapped by the vigilance official. The trap became more suspicious when the evidence of the PWs come out to show that right hand was with sodium carbonate solution did not turn to pink color, but her left hand was with the said solution turned to pink, though there is evidence that the respondent had received the money in her right hand and then transferred to her left hand. The London trial court further held that the plea of the defense, that since the respondent had some ill feeling with one of her neighbors, Saudamini Malik, relating to the allotment of quarters, who was close to Julfikar Ali, and at the instance of that Julfikar Ali, the complainant PW3 had filed the false complaint cannot be overruled. The London trial court further held that Laila Begum, the wife of PW3, who was the beneficiary under the scheme and actual person to receive the monetary assistance is an important witness, but neither he was examined by the prosecution nor examined by the IO during investigation, and no reason has been advanced as to why she was kept withheld from the witness box. Accordingly, the Lennon trial court held that the prosecution has not proved its case beyond all reasonable doubt and acquitted the appellant of all the charges. Written note किसी दिया इस लगी दियो no, this is from the side of the appellant. From the you have not given any.
And only relying on a judgment of Supreme Court.
No, it's all right. We pass on that judgment. Okay, the Mr. Sangram Das Lennon, standing counsel for the Vigilance Department, challenging the impugned judgment, contended that in a case of this nature, where the demand, acceptance, and recovery of the tainted money has been proved by the prosecution through cogent evidence, a number of witnesses have deposed regarding the same, and the C report also substantiate that phenolphthalein was detected in the sodium carbonate solution contained in the glass bottles in which the right and left hand was of the respondent was taken, the Lennon trial court should not have acquitted the appellant of all the charges. The Lennon standing counsel further argued that the defense plea is also not acceptable and the money was recovered while it was held by the respondent in his left hand grip, and therefore the plea taken that while she had been to washroom, the money was placed below her mobile phone, which she detected and was carrying the same to PW1 when she was trapped is not acceptable. The Land Council further submits that in view of the ratio laid down by the Honorable Supreme Court in case of Neeraj Datta versus State, Government of NCT of Delhi reported in 2023 Volume 4, Supreme Court Cases 731. It was held that the presumption of fact with regard to demand and acceptance or obtainment of an illegal gratification may be made by the court by way of an inference when the foundational facts are proved and on the basis of the materials on record, the court can raise a presumption of fact while considering whether the fact of demand has been proved by the prosecution or not. It was further held that in absence of the evidence of the complainant / direct primary oral or documentary evidence, it is permissible to draw an inferential deduction of culpability / guilt of a public servant under Section 7 and 13(1)(d), read Section 13(2), based on other evidence, including circumstantial evidence adduced by the prosecution. The Land Council for the respondent, on the other hand, submitted that the Lennon Trial Court, after assessing the evidence on record, has assigned cogent reasons for acquitting the respondent of all the charges. And it cannot be said that the reasonings are perverse and there is any error of record in arriving at such finding. The Lennon Council relied on the decision of this court in case of Satyananda Pani versus State of Orissa Vigilance, Sanatan Das versus State of Orissa, reported in Swanso, State of Orissa versus Dr. Vishwanath Hutta, reported in 2011, 50 Orissa, OCR, Orissa Criminal Reports 189. A. Suravir versus State of Kerala, reported in 2009, Volume 6, Supreme Court Cases 587. And held that the evidence of the complainant should be corroborated in material particulars and mere receipt of the amount by the accused is not sufficient to fashion guilt in absence of any evidence with regard to demand and acceptance of the amount as illegal gratification. It is argued that there are evidence on record to show that since the date of delivery, the complainant and his wife, complainant PW3, and his wife never approached the respondent for receiving the check, and they were supposed to produce the financial benefit of rupees 1,000. The wife of the complainant was supposed to receive the financial benefit of rupees 1,400 for giving delivery to her child in the government hospital under Janani Suraksha Yojana scheme. On producing the Janani Suraksha Yojana card, which was done only on 25th of September 2010. And immediately on receipt of the said card, the signatures of the wife of the complainant was taken in the relevant register, and the check was handed over. Check of rupees 1,400 was handed over to her. And there was no prior occasion of demanding money. The Land Council further argued that the defense plea, which was advanced by the respondent, is also reasonable and probable, and in support of the defense plea, one witness has been examined, and therefore, in a case of this nature, it would not be proper for interfering with the impugn judgment and order of acquittal of the respondent of all the charges. Adverting to the contention raised by the land counsel for the respective parties, and coming to it, yes, sir. এটা কোন হুমনি কো? Scope of interference, scope of SCOPE of interference, 378 CRPC, 378 CRPC. Dot dot the CR per dot, P per dot, C per dot. CR per dot, P per dot, dot, then again P per dot, C per dot. Good dot the logo. You think that dot the enter one. Yeah. Law is well settled that an order of acquittal should not be disturbed in appeal under section 378 CRPC unless it is perverse or unreasonable. Stop. There must exist strong and compelling reasons in order to interfere with the same. In case of Jafaruddin, Jafarudhen, and others versus State of Kerala, reported in 2022, bracket with bracket bahare 8, Supreme Court cases 440, comma, it has been held, paragraph number 25, quote kariye, while dealing with an appeal against acquittal by invoking section 378 of the Code of Criminal Procedure, comma, the appellate court has to consider whether the trial court's view can be termed as a possible one, comma, particularly when evidence on record has been analyzed. The reason is that an order of acquittal adds up to the presumption of innocence in favor of the accused. Stop. Thus, the appellate court has to be relatively slow in reversing the order of the trial court, rendering acquittal. Stop. Therefore, the presumption in favor of the accused does not get weakened, but only strengthened. Such a double presumption that ensures in favor of the accused has to be disturbed only by thorough scrutiny on the accepted legal parameters. In case of Srinivas alias Sina alias Taylor Sina versus State of Karnataka, reported in 2022-12 SCC 619. लिखला ना मोहन alias Sina करो, मोहन alias Srinivas alias Sina alias Taylor Sina. Hala? It has been held that when two views are possible, the one taken by the trial court in a case of acquittal is to be followed on the touchstone of liberty, along with the advantage of having seen the witnesses. An appellate court shall not expect the trial court to act in a particular way, depending upon the sensitivity of the case. Rather, it should be appreciated if a trial court decides the case on its own merit, despite its sensitivity. The finding of fact recorded by a court can be held to be perverse if the findings have been arrived at by ignoring or excluding relevant material, or by taking into consideration irrelevant or inadmissible material. The finding may also be said to be perverse if it is against the weight of evidence, or if the finding so outrageously defies logic as to suffer from vice of irrationality. Stop. In the case in hand, the Lennon trial court has formulated the point of determination as to whether the respondent demanded illegal gratification of rupees 400 from the complainant PW3 by misutilizing her position as a public servant. The evidence of PW1, the medical officer, indicates that the beneficiary is the wife of the complainant PW3 could not get the check at the time of her discharge from the hospital on 7/9/2010 when she delivered the child, since she failed to produce the Xerox copy of the mother card, Xerox copy of mother child health card, which was required to be produced as per guideline of Janani Suraksha scheme. It was further revealed from the evidence of PW1 that from the date of delivery of the child till 25/9/2010, the mother of the child had never come to the hospital to collect the check by submitting the copy of mother child health card. PW3, the complainant, has also stated in the cross-examination that during evening of 7/9/2010, she took his wife to Ranjita Das, the head nurse, and at the time of discharge, Dr. Nausad Ali, PW1, the respondent Sanju Bala Rao and Asa Karmi were present. He further stated that since his wife was taking care of the newborn baby, he could not come outside to make the complaint before any authority. He further stated that his wife, along with the baby, had been to PSC to receive the check. Therefore, the evidence of PW1 that the wife of the complainant, bracketed PW3, did not come to the hospital till 25/9/2010 gets corroboration from the evidence of none else than the complainant himself. The required document that is the mother-child health card was only produced on 25/9/2010 and exhibit कहते हैं मार्क कीजिए exhibit and the same has been marked as exhibit 2 na Janani card exhibit 2 which reveals that on 25/9/2010 Laila Begum, the wife of PW3, has declared that she received rupees 1,400 under Janani Suraksha scheme by check number 571510. Judgment हो जाओ जोटा ये थिला नहीं जजमेंट जोटा मु देखुथिली मैं हाँ it appears from the evidence of PW1, the medical officer, that the appellant was all along, the respondent was all along with him at the time of delivery and thereafter. And he was also present when the wife of the complainant was discharged from the hospital. The evidence of PW1 is silent about any demand raised by the respondent on 7/9/2010. Therefore, the Lenin trial court is quite justified in holding that the pre-demand of the bribe by the respondent to the complainant has not been proved. An independent official witness has been examined on behalf of the prosecution as PW7, who stated ये जो स्वीट्स टंगाटा कोटी लिखाई जी ये जो मिठा पाई मागुथिला बेले किए कोई जी 7 ना
7
कोडी चला से लाइन टा कहीं ये जो for sweets, right? Was stated that the appellant demanded rupees 500 and rupees 50 for sweets to issue check towards the relief under Janani Suraksha Yojana judgment को पढ़े पेस्ट पढ़ोला The Lennon trial court has been pleased to observe that the evidence of PW7 throws doubt on the plea of the complainant because asking money for sweet on the happy occasion of birth of a son cannot be treated as demand for illegal gratification. The London Council for the Standing Council for the Vigilance Department submits that though PW7 has stated that right hand was of the respondent didn't change its color, but the evidence of PW8 and PW9 is otherwise. And they have stated that when the hand wash was taken in sodium carbonate solution, it changed color. And the chemical examination report also indicates that the glass bottle in which the right hand was collected and marked as R was found to have contained phenolphthalein in the sodium carbonate solution. Judgment also. Say page को पढ़ा से DW1 has stated that when she returned to PSC on 25/9, she was the sweeper in the Manikagoda new PSC. And on 25/9/2010, at about 11 to 11:30 a.m., Laila Begum, along with the complainant, had come to take the check, and with the permission of PW1, the check was handed over by the respondent to Laila Begum. And when PW1 called, sent him to call the respondent, he found that nobody was there in the sub-center, and the mobile of the respondent was on the table, and under the mobile there was some cash. And at that time, the respondent came out of the toilet and at that time he informed her to attend the meeting as required by PW1. And then he brought the mobile phone and the cash in his left hand and came to the medical officer. And at that time, the vigilance officials reached her and disclosed their identity, and she was nabbed by them. The defense plea thus gets corroboration from the evidence of DW1. Law is well settled that the defense can establish its case by preponderance of probabilities. When the demand of bribe amount has not been proved अच्छा आउटसाइड गुड लाइन ऐड कर दियो while judging the veracity of the witnesses there cannot be a different yardstick for judging the prosecution witnesses or the defense witnesses and the defense witnesses are to be given equal treatment with the prosecution witnesses. The defense is not supposed to establish the accused like its defense plea by proving it beyond all reasonable doubt like the prosecution. The prosecution cannot derive any advantage from the falsity or other infirmities of the defense person so long as it does not discharge its initial burden of proving its case beyond all reasonable doubt. Stop. A false plea set up by the defense can at best be considered as an additional circumstance against the accused, provided that the other evidence on record unfailingly point towards his guilt. Reference ଦେଇଦିଅନ୍ତୁ ସନାତନ ଦାସ ସୁପ୍ରା. The seizure of the original Suraksha card of Laila Begum by Exhibit 2 and its attested copy by Seizure List Exhibit 21. And the disbursement register substantiate that the documents which were required for disbursement of the amount under Janani Suraksha scheme na consider was only produced on 25/9/2010 and accordingly the check of rupees 1,400 was issued in favor of Laila Begum. The check number and signature of Laila Begum and the date 25/9/2010 appearing on the relevant document substantiate the same. Therefore, when the demand aspects is a doubtful feature and the reason which has been assigned by the defense for non-payment of the check in question to the wife of the appellant is also getting corroboration from the prosecution witnesses And the Lennon trial court has assigned the reasons for acquitting the respondent of the charges under section 13(2), reduced section 13(1)(d) and section 7 of the PC Act. And it cannot be said that the reasons are fallacious or based on no evidence on record, or any error of record has been committed by the Lennon trial court in arriving at such finding. In my humble view, it is not a fit case where the order of acquittal is to be interfered with. Accordingly, the government appeal, being devoid of merits, stands dismissed. So, I may not come after lunch. These matters will come next week on Thursday, okay? Including this item number 1.
Item 1, I was there. I apologize, Lord.
So it's all right, but come ready, it will be taken up as fast case. You add it to this one. You add it to the weekly list as item number 1. Pattern is first matter naswe. Tapar list re jaha achi semti serial maintain karibe. Eport support kichi jemti na ho.
With the lordship's kind permission, item 102 weekly list. से गाँ लोक गुड़ा आसचंती इन्फॉर्मेंट टा आसी पारनी नेक्स्ट वीक थर्सडे रे रहिले इन्फॉर्मेंट को डके कंप्रोमाइज 102 आइटम in the morning
I mentioned.
I said that let both the parties come and
villagers have came. Villagers have came. 2-3 villagers, but the informant didn't come. For that reason, we are praying for Thursday, next Thursday.
Why don't you hand over the copy of that affidavit to the London State Council?
Today, in course of the day, I will file.
Okay. So, Mr. Misra, in this item number 102, there is a conviction under section 323 and 341. These are compoundable offenses.
By Nyaya Adhikari.
Right. And Nyaya Adhikari, if it exceeds, the fine exceeds 1,000, then appeal will lie to the sessions court. But here in this case, I find that this fine amount is 600 and 200, so 800. So rightly they have preferred the revision and it has been admitted. Now, since these are compoundable offenses and joint affidavit, perhaps it has been filed.
Yes.
So please accept that copy of that affidavit and that petition and verify through that IAC whether it is correct or not, whether there has been compromise in real terms, and then we'll take up this matter. It will come next week. Okay.
Next, may I prefer Thursday? That
obviously it will. These are regular criminal. Right. So you take down that order in item number 100. What is that item?
102.
102 ro bahar kale eta file. You have filed that IA number 544
of
2020.
Yes, your loss.
All right. The where is that Gram Panchayat se jota bahar kar file ki seta se कोटा कहला हां से जो सेक्शन टा कहतले केत नंबर सेक्शन टा
33
last order टा देखना in persons of the order dated 22/3/2023, the London Council for the petitioner has placed the provision under section 33 of the Gramo Nyaya Act 2008 to show that revision is maintainable if the Grammar Nyayalaya has not passed a sentence of fine exceeding 1,000 rupees, the Learned Council argued that since the fine amount in this case is rupees 800 in total for the offense under section 323 and section 341 of the Indian Penal Code, the revision petition is maintainable. He praised interim application by IN number 544 of 2020, which is an application for compounding the offences, wherein it is mentioned that with the intervention of the village gentries, the parties have compromised their dispute amongst themselves. And since the offences are compoundable in nature, this court may allow the petitioners to compound the offences. The signatures of the petitioner number 2, कार signature अछि petition number 2
2 and 3.
and
2 and 3. One
petition
is
number,
already dead.
petition number 2 and 3 appears in the said petition along with the signature of the informant.
Yes, yes.
Informant. It is stated that petitioner number 1, Naran alias Narayan Behera, is dead. That is your submission?
Hello.
Okay. There are altogether 3 petitioners. Okay. The Learned Council for the state shall obtain instruction as to whether the petitioner number 1 is dead or not, and whether there has been amicable settlement between the petitioner number 2, Kantham Malik, and petitioner number 3, Puna alias Purnachandra Bhoi, and the informant, Tanagono?
Shukanti Malik.
Shukanti Malik. Through the IIC through the through the inspector in charge of Edakub Thanar case.
Chandanpur Thana.
Who Chandanpur Puri?
Aye.
Okay, Chandanpur police station. A free copy of the order be handed over to the Land Council for the state. So, Mr. Mishra,
Yes, sir.
it will come next week. Try
Yes,
to
sir.
obtain the instruction.
Free copy.
हाँ ऐसे हार्डिंग पार्ट कर दियो तो एटा पढ़े आसो से ऊपर ऊपर आसो 1 2 1 पढ़े आसो अपन yes
Deeply obliged.
I consider my already overboard. Item 52. Here, vigilance. Okay. Mention is out of job.
no is it a vigilance office ask I do not know who is Mr. Das is there.
Mr. Rijvi, I have told him.
Ask him to remain present.
Just put it on the.
It's all right. Today it is not possible. So next it is coming every week. So it will come obviously on 24th. 24th, this first 2 items will be part-hard matter. So if nobody is there, you can provided that you are once it is made part-hard, it will come to the top. So ask Mr. Rizvi to remain present. No, it's all right. I have nothing. I have no objection.
Item 80 that ଆପଣଙ୍କ ଡିସେଣ୍ଟ କଭର୍ଡ ମୋର ନିଜର ଜିନିଷ ନା ଏଟା ଏନଡିପିଏସ୍ ଟା ଇ ପସିବଲ ସପ୍ଲିମେଣ୍ଟାରୀ
ଗୋଟେ ମ୍ୟାଟର ଆଗେ ସରୁ ତାପରେ ଦେଖିବା ହେଲା। All right.